Good evening. Happy New Year and welcome to the January 7th, 2014 Zoning Board of Adjustments meeting. My name is Kathy Hooten and I am the chairman of the Zoning Board. The Goffstown Zoning Board is an elected board of 5 members and up to 5 appointed alternates. Currently, the board has 5 elected members and 4 alternates. If anyone is interested in serving on the Zoning Board of Adjustments, please see Brian Rose for more information. The board has a posted agenda for each meeting and tends to follow the items in order. The board will open the public hearing on an application to receive testimony from applicants, abutters, and affected parties, and ask questions about the appeal. The public hearing will then be closed and the board will enter into a deliberative session to discuss the merits of the appeal. For each application to the board will decide to approve with conditions, deny, or continue to a later meeting. You are welcome to watch the deliberations this evening, or you can contact Brian Rose at the town hall to get the results. For an applicant's request to be approved, there must be an affirmative vote of at least 3 members. An applicant can request a continuance if there is not a full 5-member board to act on an application. That we will have tonight, a full 5-member board. If you are aggrieved by a decision made by the Zoning Board of Adjustments tonight, you have the right to appeal to Superior Court. However, before appealing to Superior Court, you must request a rehearing with this board to preserve your right to appeal. Rehearing requests must be filed within 30 days of the decision and state all reasons why the decision was illegal or unreasonable. Failure to request a rehearing may forfeit your ability to appeal to Superior Court. And with that, I would like the members and staff to introduce themselves. Joe?
Joe Femino, alternate.
Kathy Champagne, alternate.
Alan Yaton, alternate. Leonard Stewart, vice chairman.
Gail LeBrecq.
Vivian Belondo, member.
And I'm Brian Rose, the Planning and Zoning Administrator.
That being said, I'll entertain a motion to approve the minutes for the December 3rd meeting.
So moved.
Seconded?
I'll second. No fight.
Either way.
All those in favor say aye.
Aye.
Opposed? The motion carries. The minutes are approved.
Who was the voting alternate? Because you didn't assign one. Okay. Well, yeah, because he seconded the motion.
Okay. On the minutes. Now that we have the 5th member has arrived for the zoning Board of Adjustments, I'd like her to introduce herself to you.
Joanne Duffy.
Thank you. Okay, we will begin the public hearing. Herbert Edwards and Athena LaFlamme Edwards, applicants/owners, are seeking a variance to convert an existing single-family home into a 2-family home in the commercial zone. The home was previously a 2-family structure that was converted to a single-family structure in 2010. The variance is now needed because Section 311, Table A2 of the Goffstown zoning ordinance lists a 2-family dwelling as a use not permitted in the commercial zone. The property is located on 754 Mast Road, map 15, lot 49 in the commercial district. I'll entertain a motion regarding regional impact.
So moved. Second.
Been moved that there is no regional impact. This has no regional impact. It's been seconded. All those in favor say aye.
Aye.
Opposed? None. The vote carries 5-0-0 in the affirmative. Let's see, is Mr. Edwards or Mr. and Mrs. Edwards? And would you please come step forward to the microphones and let us know what you're planning on doing? Could you introduce yourself?
My name is Herbert Edwards. I live at 754 Mass Road with my wife. My wife and her mother purchased the property in 1967 as a two-family. And it stayed that way until, I think, 2009. We had a fire up there. My son was living up there, and we had a fire up there. That time, I kicked him out, and I said, nobody will ever live up there again. But circumstances have changed, and we now find it necessary to change it back to a two-family, just so someone can live up there to help my wife maintain the property after I'm gone. It's, you know, the neighborhood is, there's an apartment house to the south of me, cabinet shop to the north, then LaPointe's Insurance with 2 apartments. Auburn Hardware is right there. They have 2 apartments. So it won't change the flavor of the neighborhood whatsoever.
Can I ask you how big this area is that you're making into a duplex? The second, do you know how much square footage is involved?
It's about 1,200 square feet, 1,300 square feet. It's not a big house. It's on a small lot. Unfortunately, when the Roy farm was chopped up, it was just that, chopped up. No zoning laws then, I guess.
Perhaps not.
My driveway and the Mass Road Kitchens is the same line.
Okay. All right. Does anybody have any questions?
I just have a question. You're not changing the footprint of the house?
Not at all.
Is this going to be intended as a rental unit for income, or would you be moving a family member?
No.
Once it's a two-family?
No, she would not want anyone outside to move in. I've talked to my stepdaughter, and her husband have agreed to move up there, but not until it's needed. We wouldn't want someone outside moving in. So it's not a rental property, no.
So you would do the renovations and essentially have a vacant second unit until such
Right.
times as they needed to move
Right.
in for care.
Right now there's a stove up there that I use during the holidays. And a refrigerator. The important stuff.
And there were full cooking facilities
Yes,
in
there was a full
before the
apartment.
fire?
Yep. Yes.
When your son lived there, did he have a kitchen and everything upstairs?
Oh, yeah.
So
That's where the fire started, in the stove.
And there's a kitchen on the first floor now?
Yep.
So, what's your concern? Oh, all right.
My question to Madam
Yeah.
Chair is, isn't it still a two-family? Everything's still there.
As it says in the application, they had it converted back to a one-family. And since then, the zoning ordinances have changed because of the zoning of the property. So now he needs a variance to request it being a two-family where it's located.
Yeah.
The question I'm getting at is...
If I can answer.
Yeah.
The property was zoned commercial for a long time. It wasn't just recently changed or anything. It was a non-conforming two-family at the time. And when they came to the town, they requested to be able to convert it to a single family to save a little bit of money on taxes and whatever, to be able to, utilize it as a one family, made it a little easier economically for them. And at the time, Derek Horn had mentioned to them in a letter which I think I attached to
It's
your.
in the package, I was just looking at it, yeah.
It basically just said, if you convert it, you're going to lose your grandfathered right, and that if you ever want to go back, then you're going to have to go for a variance.
Right, but I understand that. But the applicant just stated that there's
And refrigerator.
still divided up into a two-family. It was never, did he ever get a building permit, Madam
A
Chair?
building permit is on file to convert it, yes. So we do have a building permit. I don't know how long he stated that there was a fridge and a stove up there, but I don't know if that's been there for the entire time or if it just went back and put it in, because there should have been an inspection to go and make sure that there is no, cooking facilities and refrigerators and all that up there. But I don't know.
Madam
Yeah.
Chair, I didn't have a chance to go visit these places, but I know this place now that he explained it. I have to say, my mother-in-law lived there for about 5 years, in the 70s. And the stove and refrigerator was sort of built in. Why they didn't move it out, probably that's the reason why. It's a small apartment. It was a very small apartment.
It is.
She had a little dog named Penny that drove me nuts. But anyway, she lived there for about 5 or 6 years. So now I know where the house is.
I had a question about the impact fees, I guess for Brian. When, when this was a two-family, was that considered as part of the inventory when the impact fees were put together,
Right.
possibly as a two-family? Because if that's the case, I don't think that they would be necessarily charged a fee, even though they hadn't paid in the first place, because I ran into that issue where I worked and had checked with the person who wrote the impact fee ordinance, and he said no, if it was included as part of the inventory initially, then they wouldn't have to do that. I'm sorry. Just a question.
Yeah. I can double check on that. I mean, that's not necessarily something that's under this
Right.
action tonight for the zoning board, but I'll
It
double
would
check
have
on
a
how
financial
to-
impact on the applicant, though. That's just why I bring it up.
It could be a condition of consideration.
Mm-hmm.
Okay. Does anybody else have any questions of Mr. LaFlamme? Edwards? There being none, thank you very much, and now we'll see if any of your neighbors or butters or any interested people would like to speak.
All right, thank you.
Thank you. Are there any abutters present that would like to speak regarding this application? Are there any interested parties? Is there anybody else here that would like to speak about this application? Mr. Edwards, is there anything further you would like to say?
No, it's just, I am concerned about my wife being able to stay there.
Uh-huh.
Both her mother and father died there. Her aunt died there. She's going to die there.
Okay.
And she may kill me there, too.
Man's favorite last word, but, okay. Okay, that being said, I'm going to close the public hearing and we will deliberate. 1, 2, 3, 4. We have 5, so, however, the alternates are welcome to deliberate, but they will not be able to vote.
I'll make a motion to approve the variance for the two-family dwelling as requested.
Second.
All those in favor say aye.
Aye.
Opposed? There being none, the motion carries 5-0-0. You are once again a two-family. I would, on the record, like the issue of the impact fees to be revisited.
I'll go and double check how to assess that.
and by the staff. Thank you, Brian. Thank you very much.
Thank you.
Yep, stay warm. Not a chance. Let's be glad we're not in Fargo.
Might be warmer, you never
Might be
know.
warmer there now, huh?
It's 6 degrees in Atlanta this morning, they said. 6 degrees.
Okay, the next applicant is Jack Nazer, applicant and Tower Growth Partners LLC. Owners are seeking a variance to construct a gas station and a convenience store with a coffee and donut counter, proposed as Dunkin' Donuts, without any seating, but including a drive-up window. The variance is needed because restaurant with drive-through service is listed in section 3-11, table E4 of the Goffstown zoning ordinance as a use not permitted in the industrial zone. The property is located on Goffstown Back Road, map 6/1-3 in the industrial zone. I'll entertain a motion on regional impact.
So moved.
Second.
Recuse myself.
So, just a sec, we have a motion.
Exactly what was the motion on regional
And the
impact?
regional.
No regional impact.
I'm looking at the staff recommendation on this. There was indications, this is within a few hundred feet of the Manchester line, that there was a potential regional impact on this.
Potential, but that doesn't say it.
Yeah.
Well,
There's a motion
My-
on the floor and it's seconded to accept it. Len is bringing up, just for discussion purposes, a point that I feel is well taken because it is part of the staff recommendation.
If you'd like, I can speak to my recommendation.
Yes, Brian, why don't you speak to that?
There's in the back page of the report, there's all the criteria that are supposed to be met, and the only two criteria that I really felt made it possibly meet this regional impact was that it's within close proximity to the borders of a neighboring community, which doesn't necessarily mean that it's going to cause a regional impact, but it's something to be aware of. And then down below, I put possible on the proposed developments that generate 100 or more vehicle trips per day into an adjacent community as determined by the most recent published version of the trip generation manual. And I don't really have the data on how many trips per day that this is going to generate. It might be something that you might want to ask the applicant if they have that data, or if you feel like it's going to be higher than that, then based on other things that you've seen similar to this, I'd say it's probably close, but I don't know.
This is the property abutting the city of Manchester.
It's not directly abutting. There is one property in between.
Right.
So
I tend to agree with you. That's very seldom. But yes, there was a previous development years ago, and Manchester was concerned about the regional impact.
Yeah, now-
because of the notification not made.
I also feel to inform the board that Patty, when she was sending out notices to the abutters, she did go ahead and send out a notice to the city of Manchester and to the Southern New Hampshire Regional Planning Commission,
But she hasn't
Just-
heard back from them.
just to cover that aspect.
She hasn't heard back from them yet.
Well, as long as she sent the notices, I'm fine with that. The last time it was something.
What was the date that those notices were sent on?
They're usually sent about 2 weeks prior to the meeting. We get them, in this case, it was prior to the Christmas time period, because I had gone through and reviewed all the applications that we'd received prior, and then had it all ready before I left for my vacation. So they had a few extra days, I think, on this one.
No response from Manchester?
Not that I was aware of, so they may not have a concern, which may be why there was no response.
I find it a bit hard to believe that Southern New Hampshire Planning Commission would not have responded either way. They're pretty good on their, when they're asked a question about regional impact, they have never not responded to us. That's concerning to me. What's concerning to me about this regional impact issue is that there is only one property that separates, from what I understand, this parcel and the Manchester line. And on the Manchester line side of this particular parcel are quite a few residents who very probably aren't aware that there's any development going on this particular parcel. And traffic I would assume, be a concern possibly of theirs. I'm a little concerned about the regional impact issue.
Can I make a comment? I know you haven't opened up.
I'd rather not.
Okay.
Okay, go ahead.
No, go ahead. Finish.
I'm not that concerned about the regional impact. I think that, I don't know if you remember years and years ago, there was a development going on over there, and it was stopped, or they refused to. They didn't continue the development, not only because of the sewer, but because of Manchester was not notified, and then Manchester was not happy with the big 10-wheelers and 8-wheelers coming through their town just to go to Goffstown. I don't see that happening right now, but I know that the alderman there on that back road had a statement put in, or a sign, that there was no huge tractor-trailer trucks going onto that street by certain times.
Right. Certain
That's all I
times of the
remember
day.
of it.
There's a night restriction, and I think I
It's in
think I
here.
copied an email that includes the information on that in your report. So you should have that right behind your report there. It's basically the nighttime hours between, I think, like 8:30 in the evening and 7 in the morning.
Right.
So, I mean, yeah, there was concerns previously regarding this land and Manchester being notified about it.
Mm.
So, that's something to also be aware of when you're making your determination.
And if I may, as someone who travels this road twice a day as my primary commuter route, I'd be concerned trucking restrictions aside about the commuter traffic impact there. The eastbound traffic in the morning, there are times when I have seen, depending on conditions on the Interstate 293 entrance further on down in Manchester, I have seen traffic tied up almost back to this point in the morning. If you're talking about something here with a lot of, and obviously that's probably a factor in the site considerations, you're going to get a lot of eastbound commuter traffic in and out in the morning, how this is going to affect the traffic flow in that area. And as was mentioned, the residences in Manchester that are just to the east of this location are going to be impacted by it. I think there's a strong argument to consider the regional impact and to
To that point, though, the criteria that I mentioned, it speaks to generating 100 or more trips into an adjacent community, and those are trips that are already generated by other means. So those are, people going that way, but it may cause a draw for people to go that way because of it now being there. So I don't know if it's going to increase the amount of traffic going by there.
And I can see it also creating traffic problems, people turning westbound on the back road and attempting to make left-hand turns into the property during the morning traffic rush. I think there's some serious regional traffic considerations that should be looked at.
Joanne?
I don't have any problems with this having regional impact. Sorry, I don't agree. The regional impact is something that really has a major impact on the abutting community, and certainly the city of Manchester has gas stations and convenience stores throughout. And I don't think adding a convenience store towards the border of Manchester will make any difference at all. I'm not talking about traffic issues or anything like that. I'm talking about regional impact to the city. I just don't see it at all, not with something that size.
There's a convenience store right in Manchester on down the back road, and there's a Dunkin' Donuts right on Port Eddie Road. I mean, why should the people from Manchester go to Goffstown?
But that has nothing to do with regional
I
impact.
mean, you're talking about regional impact that's going to bother or have an effect on the Manchester, on Manchester itself. Anyway.
Okay. I've stated how I feel about it. It's certainly stated. We have one that's unstated, but do you have anything to say about this?
I made the motion to vote for,
Okay.
so
Okay.
that's my opinion.
Okay.
So there's no regional.
No
impact.
regional impact.
Okay. Okay, so all those in favor say aye.
Aye.
Opposed?
Nay.
Nay. Motion carries 3-2. There will be no regional impact. Okay. And, sir?
Okay, my name is Jay Heavysides. I'm from Meridian Land Services. We're the engineering and surveying firm that put this plan together. With me is the applicant, Jack Nasser, and also the owner of the property, Steve Silverberg. They're sitting in the back. Put up on the easel the location, but apparently everyone knows where this site is, but it is located one property up from the Manchester town line. Currently, Tower Lane has been constructed down to a cul-de-sac, and this is an industrial subdivision. The front two lots, back in the 2004, had site plans approved for large industrial buildings with loading docks and such. What is being proposed is a gas station with a convenience store. It's being located here because of the current traffic that is on Goffstown Back Road. The facility will feed off from that existing traffic. It might generate some, but the intent really is not to become a destination, but to take advantage of the traffic that goes by there in the morning and in the evening, all day long. So what we are here for a variance for is a Dunkin' Donuts drive-up window. Because this is in the industrial zone, a restaurant is allowed by special exception, but a drive-up window is not allowed.
That's not true, but go ahead.
That's not right.
No, could you repeat what you just said?
A restaurant is allowed by conditional use and by special exception in the industrial zone. But a restaurant with a drive-through service is not an allowed use in the industrial zone, according to Table E.
You brought up an issue that I've been discussing today with Brian and others, which is the ordinance that you're coming in under, which is E4, page 14, is a restaurant with a drive-through service.
Correct.
And to be perfectly honest, and because it's a non-permitted use in the industrial zone, you need a variance.
Correct.
When you go to the next page, and I think that's what you were referring to, under F8, which is on page 15, a drive-through service with any retail establishment needs a special exception in an industrial zone.
But at the top of that page, F, retail,
Yeah.
trade, except motorized vehicle and restaurant uses.
Right, and then I go to just to tell you where I am, and we
Okay.
did come to how to get to yes with this.
Okay.
A restaurant in the definition primarily states that it is to serve food and beverages primarily to persons seated within the building.
Right.
That distinguishes it from a drive-through service to me. A fast food restaurant is one that orders are not generally taken at the customer's table,
Right.
which tells you there would be tables there,
Mhm.
and there would be seating. So, we can get there from here, but the reason that you have come in under it being a possible restaurant, personally, I see it as a drive-through service, not a restaurant,
Right.
because you are not going to have seats in it.
Right. That's where trying to figure out where to come in has been the tricky part because of the drive-through.
Right.
We knew we weren't really a restaurant, but once again, because of F saying except motorized services, we felt we couldn't go in under that. So that's why we went back to this is kind of serving food. How does this service window come
I think we're in
in?
between the two of them. And the one stipulation that I really want to make here, or bring it to the attention of the members, is that this is not a restaurant.
Correct.
And however, the variance would allow it to be a restaurant if it's granted, unless there is such a condition that would state that no one is to be seated and that it is to be accepted in the context of the application and the wording of the application. So I just want to make it perfectly clear to these members of the board that we are not looking at a restaurant. We are looking at a drive-through service that has, we are looking at a service, the convenience store, and a Dunkin' Donuts counter service, which is going to allow drive-through. So I wanted to clarify that because you did bring that issue up.
Right. Well, thank you, because we didn't see how the restaurant fit in either, but we couldn't find, we seemed to be bouncing back and forth, so we picked what we thought was the best approach.
Okay.
But it is, we're really here just for the drive-through service.
Right.
Which doesn't seem to be allowed in the industrial zone.
Madam Chair, is it okay if I address the issue?
Sure.
In my determination in trying to help them, figure out how to best go along, I did determine it was restaurant, and that's why I told them to go with that. I looked at, Dunkin' Donuts as they're serving food, they're serving drinks. It's a fast food service, and whether they have tables or not, I think the definition of restaurant, fast food restaurant in our ordinance doesn't necessarily mean that you have to have tables or you have to not have tables. It actually doesn't really speak to whether a person is seated. The other definition does, but it basically just says it's an establishment that offers quick food service, which is accomplished through a limited menu of items already prepared and held for service, or prepared, fried, griddled, or grilled quickly, or heated in a device such as a microwave oven. Orders are not generally taken at the customer's table. Doesn't say where an order is taken. And food is generally served in disposable wrapping containers. To me, I feel like Dunkin' Donuts does fit that definition, and they can go under this application that they've submitted. And I would prefer to give them the benefit of the doubt that they've submitted an application under something that they feel they can fit under, and I feel they can fit under, instead of somehow delaying them and making them come back for some other kind of application under a different set of rules in our ordinance.
I understand that, Brian. I understand your rationale, and I understand your interpretation of the definitions. I put out two scenarios on this table as to what the two ordinances state, and if there is anyone that has a problem with the application as presented and continuing on discussing it as presented, then we can entertain a motion on that. I don't see that. I will personally say I don't see it as a chairman being an issue. I just wanted some clarification on the two ordinances because it is unique to this particular parcel. So if you would continue, that would be wonderful.
Okay. Where was I? So we're proposing to have the Dunkin' Donuts window, and as everyone has probably experienced, drive-up windows for coffee and convenience stores at gas stations, they become synonymous. There's very few that don't have a drive-up window now, or something close by. So that's why we feel that the gas station itself is a drive-through type of service. So putting in the coffee window really isn't a big change to what is allowed for the gas station. So we feel it fits in with the spirit of the ordinance and the regulations. The window will be located on the west side, and the access will be behind the building. The stacking lane will be behind the building, and you pick up your order and go. So there's plenty of stacking facilities for this place. There are some residents nearby, but the drive-through window is located on the opposite side of the building from the nearest residence. Closest residence is to the, that's to the west, sorry about that before, the other one was to the east. The drive-through window is on the east side, the closest residence is on the west. The whole development, the building and everything is on the east side of the property. Across the street is commercial, behind is industrial, and then also across the street is agricultural with one residence, I believe it's a residence straight across the street, and then Landmark Lane out behind. So if you'd like, I can go down through the criteria of
That'd be very good.
the application. Going down through the 5 items. Number 1, granting the variance would not be contrary to the public interest because, as I mentioned, the gas station and convenience store where the drive-up windows are ubiquitous and are basically expected by customers now. It would be, the gas station is allowed, so we can go in without the drive-up window. But it does provide another service, a convenience for the community, for customers. Number 2, the spirit of the ordinance is observed because, as I mentioned earlier, a gas station by its very nature is a drive-through service, so having a drive-through coffee window really fits right in. It blends very well with the primary use, which would be the gas station. Granting the variance would do substantial justice because this just keeps sounding the same. The gas station, which is the primary use, is in essence a drive-through service. Therefore, allowing the drive-through window would not be a substantial difference. The value of the surrounding properties would not be diminished because the gas station with the convenience store is the primary purpose of the use of the site and is permitted in the industrial zone. The drive-through service window is subordinate to it. So the main use of the site is still going to be a gas station. It's not as if we're putting in just a Dunkin' Donuts. And number 5, the hardship. A1, no fair and substantial relationship exists between the general purpose, public purposes of the ordinance provision and the specific application of that provision to the property because, as we had our discussion before, the ordinance seems to be more geared towards actual restaurants type facilities. This is not a restaurant. It's just a drive-through coffee window. And it will draw its clientele from people that will be using the gas station. They will actually complement each other, the gas station and the drive-through window. And number two, the proposed use is a reasonable one because the nature of the requested drive-through service window is complementary to the gas station. And we've cited the window to be as far away from any of the existing residential uses as possible and have provided adequate vehicle stacking and maneuvering room, and it will not cause any pedestrian hazards.
Very good.
I'd be happy to answer questions.
Does anybody have any questions?
Who is the neighbor across the street? You said there's a daycare and there's
Daycare and I have to look at the list. 678. Dmitry and Tatiana Makarov, I believe is how you say it. I'm not sure.
Okay.
I think that's them. Or are they 77? No, 77.
The Schoenemans?
Schoenemans, yes, sorry. I was looking at the one up above. And what I've noticed, I looked at the aerial. We did an updated topographic survey of Back River Road and Tower Lane, but just from the edge of pavement into the property. So we show opposite us, it looks like a U-turn driveway. Notice on Google Maps, which has an image date of 2011, that that's now a solid paved driveway. This little island doesn't exist anymore. It's paved all the way in. Yes, it is.
Does anybody else have any questions? Okay, there being none right now, we'll probably ask you to come back up and answer other
Okay.
questions, because I think there might be people in the audience. And thank you very much. Okay, are there any abutters here that would like to speak to this application? Don't all jump up at once. Who raised their hand? Who wants to come first? Come on.
My name is Patrick Forge. I'm one of a group of people here tonight from Cherokee Condo Association, which is also known as Landmark Lane
Okay.
street address. In the past, as a Cherokee Condo Association, the group of other residents that are affected by the area, we kind of were concerned initially. One of the major impacts that we had initially from the last approval of Tower Lane being allowed to be there was our road impact. Our road is a private road. We allow Educare Daycare to exit onto our road. So we have a large populace of daytime traffic from the hours approximately 7 to 9 a.m. in the morning, then increasing again from about 4 to 6 p.m. when there's pickup time, plus all our children coming and going on the school buses. The other major concern that we had at the time when we were addressing the Tower Lane issue was the fact that it's also a blind intersection. At the time, we requested that they did a traffic study, and they conducted a traffic study, and there was a concern that possibly a light had to be there. With us, and the consideration of that is the fact that we're private, we're responsible for the road, if any type of impact on the other side of the road increases our traffic level, it also makes it unsafe for us. In both directions, it's a blind intersection. You have a curve coming from the Manchester side, and you also have a long sweeping road. So that's one of our first concerns. One of our other concerns is that in the original proposals, it was supposed to be a buffer zone of trees to prevent light pollution, if anything like that, and that currently doesn't even exist on the thing. There's supposed to be a 30-foot tree buffer.
Those particular issues that you're speaking of right now are really planning board issues. What we are just trying to vote on here is to whether this is a right location for this type of business, and does it warrant us to issue a variance? Does it make any justice to issue a variance to allow this to happen? The particulars, if we were to approve this, your next step would be then, of course, it would have to go to planning board for the site plan review. When it goes into that, that's when you get into the particulars of the trees and the buffers and the particulars of the infrastructure and of the plan itself, I would say, the particulars of that. So what we are looking at, pretty much you're on the right track.
Okay, one of the, I guess in that situation, it's my one concern would be is that from going through the process last time was that our understanding as the abutter people and then the process that got approved was that the businesses that were going to be allowed into that area were going to be daytime businesses. They weren't going to have nighttime operations that would increase our noise pollution and light pollution.
Excuse me. Okay.
So that was another one of our major concerns. Traffic concerns is always an issue. There's a lot of accidents that occur in that area because of the blind intersections. One of your members already mentioned that the traffic backs up from the 293 exits, and that's pretty much on a regular basis in the wintertime. And also we also have sun issues where it also creates a blind intersection, increases the blind intersections. So I would think any type of increased industrial aspect there would lessen our ability in our property to maintain that quiet zone, and it would increase our noise pollution. And it wasn't the intended purpose, as I understood it, as to what the properties would be used for. Would be kind of my last impact discussion.
When was are your condos there, or townhouses, or?
They were built in 1988.
They were built in 1988. Okay. Does anyone have any further questions? No? Thank you very much. Is there any other interested party here that would like to speak? You just state your name.
My name is Janice Shalafu. We're a direct abutter in Goffstown on the west side of the property. We're the first house in Goffstown. My husband would be speaking, but he forgot his hearing aids at home. As much as I like Dunkin' Donuts, I certainly don't want one next door to me. The reason we moved there was, again, for the quiet, for the dare, for the animals, for the darkness at night, for no traffic. In the morning, every morning, both of us are disabled. In the morning, I watch the traffic. Every single morning, it goes past my house into Goffstown. And at night, it's the opposite direction. Another thing he mentioned about the sun, if you're heading east in the morning, the sun's right in your eyes, and then at night, heading west, the sun's right in your eyes. There is a lot of accidents there in that area. we like to be home. We're home a lot. We let our dogs out and run. Occasionally, they run out that direction. They always come back. But, like I said, the reason and I know if this ever went there, there's no way we'd ever sell that house. There's no way anybody would want to live near there.
How long, when did you,
We've been living there since 2007, 6 years. My husband's a 100% disabled vet. Just like the quiet, we just like the way it is. I don't feel there is a need for a gas station there. There's plenty down the street. A Dunkin' Donuts down the street. And then with, across the street, there's the daycare. There's, people coming and going, little children, etc. Pretty much that's it.
all right, thank you very much.
Thank you.
Is there anybody else that would like to speak to this application? Oh, look at that. Okay. There being none, would you like to come forward again and address any of these issues that you've heard?
As you mentioned, most of the items that were brought up will be addressed at the planning board, the traffic, lighting, landscaping. We are here just for the use, the allowed, to get the allowance for a drive-through service window for the Dunkin' Donuts. The gas station is an allowed use even without the Dunkin' Donuts. Traffic will be addressed at the meeting. Part of the original subdivision plan for the industrial park included improvements to Goffstown Back Road, which will be implemented as part of this project, which includes the construction of a dedicated left turn lane heading west. And we've also included a dedicated right turn lane only in to the site. But once again, those are planning board issues, and we will be addressing all those when we get before the planning board.
Just one question, if I may, to get sort of a grasp on what we're talking about. The complex you're proposing, if you're familiar with the Shell station on Mast Road, on this side of the lake, this looks to be essentially the same type and scale of facility that you're proposing?
Yes, I'm not sure of the square footage of that building, and plus they have the car wash also. But yes, it will be something similar to that with the 5 service aisles out front and then a 4,500 square foot building, convenience store.
It's similar along the same line, obviously not
Right.
identical.
How many square feet?
4,500?
I think the Shell is more like close to 5,000, 49 something.
And again, close.
Okay, thank you. Well, there's nobody else that wants to come forward and speak, so therefore we will close the public hearing and deliberate.
So the question is really the variance. It's not, the way it's worded here, it says that the variance is needed because restaurant with drive-through service. So the variance is just for the restaurant, is for the drive-through, not for the gas station or the convenience store.
Correct.
Okay, I get it. So I'll make a motion to approve as presented for the variance for the drive-through.
I'll second that motion.
would like something to be added to that motion. I had written the restaurant, because it is part of the application, cannot provide customer seats or customers' tables within the site plan and is as presented in the application, which I believe you put in the motion as presented. But Brian also said in his thinking that there shall be no seating associated with this restaurant. And I, once again, I'm really hedging on the fact that we are I'm hedging on the fact that the word restaurant bothers me. Obviously, it bothers me. However, your motion deals with the drive-through. It deals with as it's presented in the application. And as it's presented in the application, it is only presented as a convenience store, a gas station, and a Dunkin' Donuts with a drive-through and no seating and no tables.
I could just add no sit-down seating with no sit-down seating.
With no sit-down seating. I'd appreciate that.
That's the only reason they went for the variance is because of the drive-through.
Correct.
Everything else we have nothing to do with really.
Correct.
Okay.
So is that an amendment to your motion?
Yes.
Do you
No
second?
seating.
You're gonna,
Yeah, you're a second.
Sure, second.
With no seating allowed.
Exactly.
Okay, with no seating allowed.
Don't bring your own.
Inside or out. Okay, so we have a motion to approve the drive-in with no seating allowed in the restaurant. All those in favor say aye.
Aye.
Opposed? None. That being said, the motion carries 5-0-0. Did anybody want to take a break?
No.
No,
No, we're on a roll? Okay.
we're on a roll. Let's keep
Thank you all for coming tonight.
Hold out. You want to get out of here before it freezes.
I don't want to go 4 hours
Okay.
this time.
Yeah, I know, we don't want to go 4 hours this time. Al, for what it's worth,
Welcome back, Al.
Thank you.
Mike Yergo sent an email to Brian and myself and Illinois. A sewer permit is going to be required.
What now?
Here.
should be in his package anyway.
Stop this.
This is a big industrial building.
Did you?
How do you close this?
That's the single family,
Okay, just
two-family.
put this back. Whoops, right here.
Yeah, we got that one.
Oh, okay.
There was two memos from Yargo that I saw.
Okay. For all those that want to go home, we have a request on the table for the rehearing from the Bel Air Nursing Home on the sign variance map 28 lot 17. All in your packages you received a copy of the letter that was hand delivered to the town of Goffstown, Brian Rose, Planning and Zoning Administrative. They cite 3 reasons why they are requesting a rehearing. The first one,
Madam Chair, I'm going to step down on this.
you're a busy guy, Al. You're a busy guy tonight.
You stepped
No,
back.
it's just, I don't want anything to do with it.
Okay.
Well, didn't you have something to do with it the first time?
Yes, I did.
Okay. But you can just step down because of.
He wants to, I guess if he wants to recuse himself, he's an alternate, he could recuse himself. 1, 2, 3, 4,
I
5.
wasn't here for any of, well, I think I might have been here for one of the hearings. I was
You
here for
were.
one. but I wasn't here for the last one, but I read the minutes,
Okay.
so.
I wasn't here I was here for the ones before, but I wasn't here for the last one, and I read the minutes of the last meeting too.
Okay.
And I feel the minutes were very well taken, and I'm very much informed as to how the meeting ran. Okay, 1, 2, 3, 4, 5 members, 2 alternates still with us, one's recused himself. The first issue, of course, contends with Kathy Champagne and the belief that there is a conflict of interest on the part of a board member. The second, they state that there is that its variance application does meet the hardship criteria, and that it demonstrated beyond a preponderance of evidence presented that the zoning restrictions as applied to their property interferes with the renewed use of property, et cetera, et cetera. The third they believe that it violated both its substantial due process and equal protection constitutional rights. And they referenced Quirk versus the town of New Boston. Yes.
Restriction of property rights not
Violate both its
related to the-
substantive due process and equal protection constitutional rights.
Okay.
Do I have any comments regarding this request for a rehearing?
Any new evidence of just what they're saying?
Just what they're saying, they don't offer any new evidence.
What they generally are supposed to do when they request a rehearing is request a rehearing and state all the reasons why they feel like the decision that was previously made was unreasonable or illegal. They don't necessarily have to present new evidence. That could be presented in a new rehearing if it is reheard, but they don't have to present anything new to the board, just reasons why they feel like the decision was illegal or unreasonable.
I don't consider the decision was unreasonable or illegal. I think we backed it up well with reasoning as far as how they didn't meet the hardship criteria and how, wait a minute, where's the other one? And the relationship that exists between the zoning ordinance and the specific restriction on this property because of how close they were to the residential properties that they abut. I think we were very clear on that. As far as Kathy being a conflict of interest, I guess I would compare that to the board's, the zoning board itself has had an attorney on the board, and so has the planning board. And they don't step down every single time an applicant is represented by an attorney. There's not a conflict of interest as far as I'm concerned. She didn't weaken their business. They already had contracted with somebody else, not with her. I don't feel that there was a conflict there.
I agree. And I'm going to jump right in on that one, because I do. I think that I read over the minutes of everything twice. I want to be clear on this. As Gail has said, there are times when on planning boards there are architects, there are contractors. People's professions bring knowledge to the boards. There are going to be duplications of people's jobs on both sides of the table. Kathy Champagne's primary discussions on this board, on these meetings, dealt with the hardship issue. She was very astute in bringing forward the issues of hardship in her comments. Anything that was relative to signs was educational, and I do not feel it was conflicting in any way with this application. I think every issue that has been mentioned here, and for the many meetings that were held, and the length of the time that has passed since the initial application was accepted until the decision was made at the last meeting, everything was covered in a very, very professional way by every member on this board. I right now sit on the fence. I don't particularly see any reason that we need to reconsider this application again. I think we've thoroughly discussed every issue with the applicant, and I don't see the request being warranted.
So I wasn't here for this meeting, but I'm trying to think of the conflict of interest. Objectively speaking, you know, I know Kathy fairly well, you know, just from here, so I'm not implying that I think that she would have had any sort of ulterior motive, but I'm thinking of a conflict of interest in this case. And I'm thinking of myself, putting myself in this scenario. I work for Comcast, so I'm thinking if Verizon came in here and they wanted to overbuild, put FiOS in our town, I would recuse myself because my decision directly impacts their ability to compete with me. So I look at this as the same scenario. I do. I mean, it's not like an attorney where the attorney's probably already gotten his commission or there's a contract, he gets paid, whether or not he wins in some cases. In this, I think that what he's saying is that a competitor had the ability to stop their competition from getting money, from making work. So that's my opinion on that.
Although everything you're saying is true, I thought a lot about it before it came to the actual time of the meeting. And the one decision that I made wasn't necessarily, do I have any sort of opportunity. It was, can I be impartial and can I make a fair decision? That's what I had to answer for myself. And I considered that very carefully because I know whether I recuse myself and then there's different people voting, which could go whichever way, or whether I stay and whichever way that goes, whatever I do, there's a consequence. And I wanted to do the right thing and make sure that if I stepped down, I was stepping down for the right reasons, but if I stayed, I was doing it because I truly believe there wasn't a conflict. There wouldn't be a bias, and I was comfortable with my decision then, and I still am.
But just to follow up, that's just you saying what you were thinking, but
that's all I can do.
I mean, the only thing I think that exists here is the doubt that the applicants have. I mean, anyone can go back and say, yeah, of course I was honest, but they have doubt. They're expressing their doubt. They are aware of the potential conflict of interest. So there's no way anyone can prove whether or not Kathy's telling the truth or not. So that's my point. Is they make a good point.
Okay. Good, I'm glad you said something, Len.
Except, I don't agree with your analogy there, because the one that you raised about Verizon Fios versus Comcast, that would be a case of to build or not build. In this case, it might have been a competitor, but it's somebody who has already been hired by the person who has done the work. Presumably, whatever we grant or not grant, this person still has the relationship with the client, and they're going to build whatever the client ends up building. It's not a case where I would see any advantage to Kathy or her company by voting against it. You're not going to be depriving the competition of business. Getting away from the conflict thing, the point that I wanted to make, and I think this is the one where it's come down to me time and time again in this case, is I don't see where they're demonstrating hardship. They're saying, oh, it's a hardship, but I don't see the hardship in complying with the current law. We're under no obligation to grant something just because they requested, and I think it's a good idea when I see no burden, additional burden on the property owner or any denial of reasonable use by just complying with the current regulation on the property, and that's what comes down to me. I don't see granting a rehearing because I still don't see any demonstration of any hardship that's been imposed on them.
Yes, Vic.
I have a question for Brian. When they request a rehearing, Brian, do they not tell you whether they have new evidence?
Again, they don't have to present any new evidence or tell me if they have anything new to present. They just have to state to us why they feel like it was unreasonably decided upon or illegally decided upon. It's the new evidence that could come forth is something that would help their argument in a rehearing scenario, but and it might be something that the board could consider if, the board was made aware of some new evidence within like a 30-day period after making a decision, and then the board could reconsider their own decision. But they don't have to provide any new evidence that shows one way or the other.
When they ask for rehearing, they'd have to point out some new evidence.
Isn't that for an appeal and not is an appeal and a rehearing two different things?
Either way.
They're pretty much the same thing.
Okay. I'm not going to, I am not going to vote for no rehearing, only because I don't want to have to start looking into attorneys. So I'm going to stay out of it. Okay? Once it gets to court, they're going to look at the video and everything. They're going to see a lot of things that we haven't seen or haven't heard. I'm just saying that I think there's some of the questions shouldn't have been asked. But that's my opinion, and I'm not going to go into it.
That's why we all are talking. We all want to put our opinions and our thoughts on the table. That's how we all make decisions here.
Okay.
Otherwise, you'd leave it all up to me.
The thing about rehearings and reconsiderations is it really just provides the board a chance at a redo, basically. A second chance to fix something you feel like may have not been quite so clean, or if you feel like there's something that the applicant has stated in their letter of request to rehear that has merit, and you want to go back and fix that, then that's when you go back and say, okay, we'll do a rehearing. But you also open that up for any additional information that they want to present. They can present that at a new hearing. So it opens up a whole nother round of public hearing and comments, and discussion where you could also make another mistake, and then we go through this again. So it's,
Yeah,
What I really
Vicious cycle.
stumble on is the hardship issue. And that's the issue I stumble about. And as far as I'm concerned, there is no hardship. And that is primary in granting a variance. And if we rehear this, the hardship issue isn't going to go away. The hardship issue will remain as it is stated. And for, again, for the fact that I do not believe that there's a conflict, and for the fact that there is not a hardship issue, and for the fact that it is clearly stated in our ordinances that there shall be no illuminated signs
Within 250
within
feet.
250 feet, and it's stated quite a few times. That 6.5, no internal illumination is permitted. Residential agricultural conservation districts. It's also restated throughout our ordinances. So it's in the spirit of the ordinance. There is no hardship. The applicant himself stated that they were one of the top nursing homes in the country.
I don't think that makes any difference whether the top nursing home or not. It states the fact that whether they're the top nursing home or not says something for that business, but it also says that they have to keep on top of it. And as far as the hardship, I agree, but I also agree that there are some cases that present a hardship that didn't really have that criteria of a hardship. And if they start reviewing all these, we're going to be, I'm just not going to, I'm on my train.
Yeah, go ahead.
I mean, if I may, I'm just going to offer a motion for purposes of discussion. I move that we do not grant a rehearing to this case. I do not see anything new in the arguments that they're making that have not been made, throughout the proceedings from the beginning. And for me, it comes down to the hardship. The other issues are ancillary. I'm not going to pick their letter apart. I don't think that some of the examples they offer at the end of their letter requesting a rehearing are indeed similarly situated. So for all of that, I move that we do not grant a rehearing.
That's been Len has made a motion not to deny the rehearing, to deny the rehearing, and Gail has seconded it to deny the rehearing. Is there any more discussion? All those in favor of denying the rehearing say aye.
Aye.
Opposed?
Aye.
1. Abstained? None. The motion carries 4-1-0. Okay. Now, in our packets, Brian has given us a list of, which is very nice, the terms of the members and the alternates appointed.
If I can just speak to that really
Yeah,
quick.
sure.
Kathy Ball, our town clerk, provided that list to me, and that basically, she asked me if I would just provide it so that you have the information, and just make note on the record that, the March elections are coming up again, and we wanted to make note that there are positions that would be available. I think Kathy, your term is up. And then Len, your term is up, and also Kathy Champagne, your term is up as well. So I know it's been short for you,
And
but
Dan
you
Doucette.
elected for a short term in the beginning. So
And Dan Doucette's is,
is Dan Doucette as well?
Yeah.
Okay. So we've got multiple terms that are up. Now, any of those people who want to run for the full position, just need to do that. I can't remember the exact dates of when they start doing the election, but I think it's somewhere
End
in
of
late
this month,
January.
22nd to the
Yeah,
31st, I
yeah,
believe.
it's somewhere in late January, and it runs for about a week or two, and then, you know, and if you want to put your name in for being on the ballot, then you can do that. Or if you're an alternate, and you just want to stay an alternate, you can just ask that you be reinstated as an alternate again, and I think you have to maybe reapply for it, but.
How long are the terms again?
3
So
years.
3 years, yeah.
And if I may, Kathy?
If
So-
you'd like to.
And just for those alternates too, I had given Kathy a heads up on this, or my intention is not to run for another elected term at this point. I've been on and off this board for the last 5 or 6 years.
On and off, on and off, on and off.
Oh, well, alternate elected, off for about 1.5 years because of work scheduling, and I think I'm going to take a year off at this point before I decide to, I might go for another board, but I'm just kind of a bit burned on it and want a year off, so my term will be available for anybody who wants to put their name on the ballot for it, because I don't intend to run again.
Why is everybody looking at me?
We don't know what you're gonna do.
Want to see what,
I have
Opportunity,
to ask
Alan,
my wife
opportunity.
well, I don't know about anybody else, but I certainly am going to miss Len being on this board because I think he brings great insight and reasoning to a lot of the issues that we have to deal with on a monthly basis, so
I agree.
thank you. Hopefully you'll be here next month.
I will be here next month. Until my term is up, I show up.
Good. Okay.
Actually, until a new member is sworn in.
One more thing to
Actually.
actually pass out.
I want to go over a couple,
Okay.
one more thing before
All
we
right.
pass that. We have the meeting schedule that was included. True Concerns, again, Tuesday, July 1st. July 4th is on a Friday, so July 1st is like a Tuesday. It is a Tuesday. It's the Tuesday of the week of July 4th. I would assume that that would be the week that people would be taken off because the 4th is on Friday. So,
Either way you look at it, you take one the next week, and they might be taken that week, and it's kind of split right in between. So I actually talked to Patty, and we felt, let's leave it on the 3rd and see what they say.
on the
but-
1st.
When June comes, we'll
We'll
find.
find,
Or,
well,
yeah,
all
the
right.
1st.
And then,
You're going to get people taking either week off, so it's going to be
I
kind of hard
think
to.
maybe we'll see what more businesses and what they're, more people are taking off, which ones become the heavy hitter side. And I think that Vivian's right in that, let's wait till we get closer to it to see who knows who on the board might be going away too, so. And then Tuesday, September 2nd is the day after Memorial Day, which,
You mean Labor Day?
Labor Day,
Is Labor Day on the 1st?
I
It's
believe.
always the first Monday.
I
Well,
think
it's the Monday of the
I
first, though.
believe it is. I think when I looked at
Well,
my
if
calendar, it
Tuesday's
is.
the second, then Monday would be the first.
Right.
There we go.
There we
Oh,
go.
my.
Oh, Lord.
Now you know why she's recording secretary, huh?
Even I
Someone
can't,
smarter than I.
The logic. I really think that one should be moved till the 9th, but, instead of the 2nd, but I'm throwing it out there for discussion purposes. If nobody objects to it being on the 2nd, you want to wait and see what goes on with when we get closer to September?
just as, I usually get the package like on Friday or Saturday. And so I try to make a point of going around and looking at these places during the weekend.
Yeah.
And that's Labor Day weekend, and that may or may not fit with everybody's thought processes, I like to go to all these sites.
I do too. And I think that's a good point, Al.
Yeah.
I think that's a very good point, because if we could get our packages earlier,
We still wouldn't do
I'm
it until
working
the
on
weekend. I mean, I wouldn't because of work.
if we could get it the Friday before that week, because the applications have to be in 2 weeks before, so it actually gives you enough time, but I'm sure Brian has other packages to make and other possibly, I think it
always
might
a
be
big-
easier to go to the 9th than it is
it's
to get the
always a big-
packages out earlier, to be honest
All
with
the
you.
meetings are always tedious to get ready. I mean, they're a big
Yeah.
chore. So I know that. I used to do it, and it's a really big chore.
So,
Just about stop
I'd say
everything.
try for the 9th, just to let people have the opportunity to,
to go over the weekend to see if we
Yeah.
get it on the
Yeah.
Friday before.
Yeah.
What do you, well, you're not gonna see it.
Well, we
well,
can come
he'll
in-
be here.
If you can
He'll
still,
be
you
here.
can
We
still,
can always come in
think about
and-
the people who's gonna
and
sit in your
what they
chair.
are Before we get the
Any,
packet.
Joe, any thoughts?
You know, because the
Doesn't
packet
matter to
No,
you?
it doesn't
on
matter.
Thursday.
The 9th makes sense. I mean,
I think the
but
9th
if,
makes
if
sense
it's
too.
if it's kept on the 2nd,
Doesn't matter to me either way.
Only thing it makes me do is have 2 meetings in 1 week, because I get the planning board on the second Thursday, so if you move this to the second Tuesday, then
Then I have sewer too.
just like this week, you got planning board this week too, right?
I think we're better off September 9th. I think we are. I think we're all gonna be back. We're gonna be on Labor Day vacation weekend.
The next week is gonna be tedious for me.
Let's change.
Seafood festival at the
I
beach.
read.
Oh, well, bring some to dinner. Bring some back.
My only concern in all these is December 23rd. I mean, to me,
That's true.
where's December?
Oh, that's the
23rd?
applications to do.
huh?
That's for when applications are due.
Okay, look at
Yeah,
So I don't think you have any concern there at all.
and actually, that
Unless you're
was,
applying for
that was for
Oh, I'm
this,
sorry.
this meeting today anyway, so
Yeah,
that shouldn't matter anyway.
Okay.
That's long gone.
okay.
Tuck.
So is there a consensus to go to September 9th?
Second, that's right.
Doesn't matter to me.
September
I'll
9th?
be here one way or the other.
I'll be here, but I'd just like to be prepared.
You know what? I'm gonna leave it until after the March election, see who's on the board, and let the new board decide what
There
they're
you
gonna do with
go.
the September meeting.
There we go.
There you go.
That's how you.
Why should anybody else have a say? Oh.
But I think that would be good, because then we know, you know.
Okay.
All right, now, the proposed zoning amendments, are we supposed to discuss these at
Nope.
all? Just look at them.
It's just for your information.
And this is going to be Thursday night. So the proposed zoning amendments that are going to be on the March ballot are going to be in front of the planning board this Thursday night?
Thursday is the public hearing. That's when we can discuss the merits of the items.
But I
and
can't
the
go.
amendments.
Is there only one public hearing?
If you have something to say, send it to me in writing.
Okay.
Not discussing this out of a public hearing notice. So, I'm
so
sorry, but that's the rules. You
Well-
know the rules very well.
What is,
I know.
Obviously,
Is there only one public hearing?
I
Or,
thought there
we've
were
already
two.
held a public hearing in December,
Oh.
and so this is the second one. And
Okay, I'll send you an email. I've been working on it all day and I'm just so upset.
Okay.
I do have a question for you though, Brian. Are the petition articles subject to discussion at the
at
hearing
the public
Thursday?
hearing, yes. However,
You can't
whether the
change
planning
them.
board recommends it or not, it still moves to the ballot because it came by petition. So that's the only difference between,
Okay, but
Two.
the planning board would make a determination even on a petition articles,
Yes.
recommended
To
or not
recommend or to not
recommended by
recommend.
the board.
yes.
can you explain the last three that were by petition? I'm just curious.
The
Yeah.
last three I can,
Dumber and dumbest.
Excuse me,
I
excuse
didn't want to
me.
get.
Sorry.
I didn't want to get there, but.
Excuse me. I really don't appreciate that statement on public television about,
I'm sorry. That's
Yes.
how I feel.
I understand that, but I don't appreciate it.
But everybody has an opinion.
I don't appreciate it.
Well,
I'm sorry, I don't
we're
appreciate it.
sorry.
We're all human.
okay.
I still
So-
feel that way.
I mean, I can tell you what they are, but we just can't have discussion about them. So, the
The public
first,
hearing, this is a public, we can talk
this is
about
not
anything
a,
we
this
want.
is not a noticed public hearing to discuss these items.
That's right.
These
But this-
items are not on our agenda.
But they're not under our purview. We could have a discussion, just a general discussion, because we're not making any
But
decisions
that's
on
not,
these.
that's, if you had put it on the agenda, be different, but it's just a FYI.
It doesn't
that's
matter.
all-
You
It's
don't
just
have to put things
informational.
on an agenda to
Okay.
discuss
It's
them.
always been
All right.
an
Okay,
FYI.
so
We're not
for-
making
for
any
all those,
decisions on
excuse me, ladies, for all those who would like to know more about the petitions and about the proposed zoning amendments, questions will be asked and answered Thursday night at the planning board meeting that will be held at 7 o'clock
At the high school.
At the high school,
at the
yes,
high school. Thank you. At the high school.
in the media center of the high school.
How long do you think it would last for?
Right. Is there any, I don't think there's anything else that we need to. Now, did you have something you wanted to pass around?
I redid the rules of procedure based on back in November when
Yep.
the board voted to put in the end of meeting time at 11 o'clock.
Do we have to follow
So, and it's basically, the motion was, unless voted by the board to go longer, you're gonna end at 11. No limit at 11.
I think it should be
I
10.
wasn't here when they did that, so
I think it should be 10.
Take a copy and pass it around.
my time would be 10 o'clock.
I recuse myself because I don't want to
I
get
have to leave.
you moved up.
Because nobody knows that, you know, you get up in the morning.
It's better than, I've stayed here till 1:30. Is there any further discussion of anything that anybody would like to bring to the board? There being none, I entertain a motion to adjourn.
I made one earlier.
This
at
is
the start of
just
the meeting.
already adopted.
Okay,
But, yeah,
It's already adopted.
they voted on it last November.
Glenn seconded it. All those in favor to adjourn, say aye. Aye. Opposed, no. Thank you, we'll see you next month.
Yes.